4CRB now presents Legal Matters, proudly brought to you by Bell and Senior Lawyers. Call them today for all your legal needs on 07 55 32 8777. This program provides general legal information only. It's not personal legal advice. Everyone's situation is different, so please seek independent advice for your own circumstances.
Well, as the promo states, welcome to Legal Matters, and it's a very good morning to Andrew Bell.
Good morning again, Colin. Great to be back.
Yeah, okay. Well, you caught us in our fundraising event last week. Hopefully we'll get those phones to ring. This is a talkback program this morning. We'd love to hear from you if you've got any legal question throughout the entire spectrum of the legal profession. We're going to be talking about blended families and wills and so forth this morning, but that doesn't mean that we won't take a question from you on any other topic. So we'd love to hear from you. 0755 208888 is the number. Do not leave it to the end of the program. All right, let's hop into the topic. Andrew, blended families. To start with, what exactly is a blended family from a legal perspective?
Well, thanks, Colin. The term's used by lots of different people to mean lots of different things, and it really matters here on the Gold Coast because we have such a high proportion of second marriages and de facto couples. We find that people think that their family situation is normal and simple until something goes wrong. Someone passes away, there's a divorce, or people need to borrow some money. So the goal today is to go through what is a blended family and some of the things that you might want to know if you're in one. So in Queensland, a blended family is an arrangement where one or both partners have children from a previous relationship. This includes married and de facto couples. And one of the most important things to understand is the status of stepchildren. So in Queensland, a stepchild has a specific legal standing that allows them to contest a will, just like a biological child. However, there is a catch. The stepchild only exists as long as there is a marriage or de facto relationship. If you divorce the biological parent, or if the biological parent's died and you remarry, then that legal link for the stepchild could be severed. So this creates a very narrow window for stepchildren to be able to make claims against estates.
Yes, okay, and there's the trick right there. All right, when people form a blended family, perhaps moving in together or remarrying, what's the first legal issue they should be thinking about? And what conversations should couples have before combining families?
Well, one of the biggest things is where are you going to live and who owns the house or the houses. So often with blended families, we have people coming in with money that they wouldn't have otherwise had if they'd potentially met in their 20s. So if you're going to live together, how is the house going to get paid for? Yeah. Who's on the title? If you're going to have a will, what's the expectation around who would inherit that particular property? So I think having a discussion beforehand around what are the finances that we have. If you're living together, I think previously in an episode we said that, 2 years is a de facto relationship. Before that, it gets tricky. But if you're already commingling funds and things, that maybe wills or binding financial agreements may be relevant before that 2-year window comes up.
Okay. All right, well, this is a talkback program. We'd love to hear from you this morning. 0755 208888 is the number. And don't forget, you can also email in your questions. They won't be answered today, but it allows us to have them prepared for next week's show. mail@4crb.com is the email address. And we'd love to hear from you. Do not leave your questions to the end of the program. 0755 208888. Let's start with wills. If someone remarries but doesn't update their will, what can actually happen to their estate?
So one thing people don't realise in Queensland under the Succession Act, if you get married or you get divorced, it revokes your will. So unless that will was specifically drafted in contemplation of the marriage, if you had a will leaving everything to the kids of your first marriage and you marry a new partner without updating it, that legal will is likely cancelled. So then you'd be considered intestate, which is a topic we covered in previous weeks, yes. Which then may decide who benefits. And the stepchildren may come in, you may give inadequate amounts of money to your new husband or wife, So if you are getting married or have a major life event, a marriage, a divorce, or even a long-term de facto move in, you should actually consider your will and making sure that it's up to date.
Yes, absolutely. Look, you can understand that this is just easy, that you go into a relationship, we don't think about the mortality of it, I'm going to be fine, I'll be okay. But the issue, moreover, is when it is you're in a family where both partners have generated the kids, well, you know that both those kids are going to be looked after in some way, shape or form. The battle here is if your partner succeeds you and then a number of years pass, or even if they don't, it may be that they look after their kids more than they look after yours, or at all. And that's the bigger issue, isn't it?
That is the bigger issue, and everyone wants their kids looked after and the best future for them. And it's very difficult to know what the arrangements are going to be.
Sure.
And often partners have discussions about what's going to happen, and then they pass their estate to the other partner when they die, and then things change, and people get upset that they don't feel that they're adequately provided for.
Yes.
And as we've said, the stepchildren standing after one parent's no longer married to the other parent, it becomes a particularly difficult arrangement. So while I don't like I'm not spruiking legal services, this isn't DIY stuff for the most part.
No. And that's a good point. A blended family is complex to begin with. So the way that it's going to come apart, whether that is in a divorce or via someone passing away, is also going to be complex. So therefore, you're better off getting the right advice and ensuring what you want to happen with your assets is actually going to happen with them.
And understanding what those are in non-legal words is the most important bit. And then you can get professionals to assist you to come up with the best structure. So, for example, when you own a house, there's two different ways of owning a house. There's tenants in common and there's joint tenants. Joint tenants is the traditional way that married couples would own a house. And under that setup, if one person dies, the house automatically passes to the other side. But if you've commingled your funds and you want to look after your kids and they want to look after their kids, it may sound less romantic, but you may want to set up a different ownership structure called tenants in common. Then you can set a specific share of how much each party owns, and then when they die, they can then specify what happens with their estate. And that may include that there could be provisions that the other partner can live there until they die. They pay the rent and the rates, etc., and keep the place up to date. But when they pass on, they lose that right to live there, and the house is sold, and it goes according to each party's wishes.
Nice. Okay, that's a great explanation. All right, this is a Talkback program. We would love to hear from you. Your legal questions are welcome. 0755 208888. Do not leave it to the end of the program. Is it common for children from early relationships to challenge a will if they feel they've been left out?
So we don't have stats on this, but it is becoming increasingly common, particularly with houses being worth so much. The normal rules would be that they have 9 months to be able to make a claim after the person dies, and that claim doesn't look at fairness. The court then has to intercede and look at what are the actual needs of these parties. And it's not uncommon for people to be either deliberately or accidentally written out of wills, or circumstances change. Someone may have had a great job when the will was drafted, so the parents didn't think they needed it as much. Later on, they've got children, no job, and the child feels that they need more funds and that it's unfair that other people are being supported more than them. So this can delay all of the distribution of the estate while this is being sorted. And typically then the estate needs lawyers, they need lawyers. It's a complicated scenario once someone decides to start putting a family provision claim in.
And again, a drain on the estate, all because it wasn't thought through, wasn't discussed through, and wasn't provided for and thought about before something happens. What steps can parents take to make sure their children from previous relationships are still protected financially?
Well, one of the things, first of all, is to understand all the assets of the estate. So superannuation is a giant red flag here. Most people don't realise that by default your super isn't covered by your will. It's a separate body of money controlled by the super fund trustee. So if you want your super to go to your children from a previous marriage, you need to put in what's called a binding death nomination with the super fund. And these can also expire. So you need to put calendar reminders in, if you put one in, if they're going to expire, to put another one in. But essentially this bypasses the will entirely and makes sure that your super goes to where you've directed it to go. Similar with life insurance. So you may have more assets or less assets in your will than you thought, depending on what stock you've taken. There's also tax implications for these things. Some of the other things that you might want to do, you may want to maximise the tax-free income by providing your superannuation to your spouse and distributing more of your estate to your children.
All right, we are halfway through the show. We'd love to hear from you. 0755 208888 is the number to call. We'd love to hear from you this morning. Do not leave it too much longer. Some people assume everything will simply pass to their new partner first, but what's the risks? What risks can that create for children later on?
Well, there's risks to the children and your partner. It's called sideways inheritance, and it's a massive risk. If you leave everything to your partner, which isn't default, by default they get $150,000, and then there's an apportionment if you don't have a will based on how many children you have. So they may not be able to afford to keep living where they're living.
Wow.
But if you did decide to make a will and give everything to your partner, once you do die, unless you've put in something called mutual wills, which is a commitment between both parties to live up to, they create a will that is the same, so the same beneficiaries, it doesn't matter who passes first. If that commitment's made, then typically that will stand and that's upholdable in the court, and there's a 2022 decision around that. However, that also assumes that no one else's circumstances are going to change. Your partner might survive you by 20 years, have all sorts of other needs, and they're still bound to that mutual will. But back to the question, what can you do to protect the kids? Well, once you die, unless you've got those mutual wills in place, your partner is free to change their own will. They might have a falling out with your kids. They might remarry. Someone else might convince them to leave their money to a family, or they may leave it to charity. Also, there's something called asset depletion. If your surviving spouse needs to go into expensive aged care, they may need the assets that you left that you were hoping to go to your children to support them. Your kids, while they're alive, typically don't have a legal right to stop a step-parent from spending what they'd consider as their inheritance once it's in the step-partner's name. So there are legal means that you can put in, including a life interest or a testamentary trust, and we can go into what those mean a little bit future, but I believe we've got someone on the line.
We do. We've got our first caller. Please give us a call this morning if you've got a legal question you'd like answered. 0755 208888. Very good morning to Lorraine. Lorraine, ask your question of Andrew.
Yeah, good morning. I want to change my enduring power of attorney, take one off and include someone else. Does that person have to come to the solicitor's office with me?
Okay, so if you want to change a power of attorney, you typically need to revoke a previous power of attorney and create a new one. When you go to the lawyer's office, the lawyer would normally see you one-on-one to make sure that you weren't being influenced. Once you've signed it, it's in effect. There's one bit at the end where the attorney needs to accept that they want to do that. They don't need to sign that at the same time that you do. So we've had instances where they're in other states, etc., where we've couriered the documents, got the attorney to sign in writing that they agree and returned the originals back to us. I hope that answers your question, Lorraine.
It does. Just a quick one. Is the enduring power of attorney valid in all states in Australia?
Absolutely. Provided it's valid in one state, there's mutual recognition across the states.
Terrific. That's all I want to know. Thank you so much for your help.
No worries.
Thank you, Lorraine. All right, if you'd like your question answered just like Lorraine did this morning, we'd love to hear from you. 10 minutes left in the show, so do not leave it too much longer. 0755 208888. Are there legal tools like trusts or specific will structures that can help balance providing for a current partner while also protecting children's inheritance?
Absolutely, there are, Colin. There's something called a testamentary discretionary trust. Now, that's a big word to get your head around.
It is.
It's a trust that's triggered when you die. And what it does is it allows your spouse to use the assets and or the income of the estate during their lifetime, but they don't own the assets. The trustee owns the assets on behalf originally of your partner, and then when they pass, then those assets can then be distributed to the family members that you specified in your will. So this has two major benefits: asset protection and tax savings. If your surviving spouse gets sued or goes bankrupt, the assets are generally protected. If they remarried, the trust assets don't become matrimonial property for their new partner, so they're protected in case they divorce.
Ooh, that's going to be an interesting topic we'll revisit. But anyway, continue.
It is. There are some specifics around that. However, if the intention is that you're making sure that your partner's provided for, but the benefit goes to your children, and we're talking blended families here, so we're talking multiple children from multiple relationships, this could be very important for your planning. And we typically advise that people get both financial and legal advice before they enter into an arrangement like this, because there are some gotchas. Additionally, if you have grandchildren and you have a testamentary trust, there could be tax benefits from them as well. In a normal trust, if you give money to a minor, they're taxed at a high rate. But in a testamentary trust, children under 18 can get a full adult tax-free threshold of about $18,000. So you may be able to use this money to pay for your grandkids' school fees under pre-tax dollars, which may be a big financial incentive for the family.
Nice. So going back to, you were saying there that it has protections for the children or grandchildren if they were to marry and divorce. Does that mean that the partner of the inheriting grandchild has no claim on the assets that are in the trust?
So there would potentially be a claim at the time of the will that sets up the testamentary trust if people feel that they weren't adequately provided for and they got their claim in within the 9 months that we discussed. However, once the testamentary trust exists, it's a vehicle like a company that is holding these assets on behalf of the beneficiaries of the trust.
Nice.
So if your partner remarried, the testamentary trust assets aren't there for the long-term benefit of your now former partner because you passed away. They're there to help pay for their living expenses, but not for them to own the assets going forward. So if that partner was to marry and then divorce, the intention of the trust was never for them to own the assets, and you would be arguing in front of the court that therefore that they shouldn't form part of the new matrimonial pool.
Nice. Well, that's an interesting little bit of information, Andrew. Another issue that often comes up in blended families is superannuation. Does super automatically form part of the estate?
Okay, so I briefly mentioned or binding death nominations before. So most super is a trust, just like that testamentary trust. So it's held by a trustee on behalf of someone, and then there's directions of where it goes forward. So there is a binding nomination, and after it expires, it becomes non-binding, which means that the trustee of the superannuation fund can decide where it goes. They may choose to follow your previous nomination, or they may send it to the estate, or they may send it to someone else they think in the family was needing of the money. So you really need to get signed and witnessed by people who aren't beneficiaries, that death nomination, and send it into your super fund. And that doesn't really matter if you're in a blended family or not. The same rules apply. Where do you want the money from your super to go? And it's the same with if you have any life insurance. Where do you want the money from that to go in the event of your death?
Okay. That's an interesting point of view. All right, we're in the final 5 minutes of the program. We'd love to hear from you. 0755 208888 is the number. You can ask any legal question you so desire. It doesn't have to be just about the topic we're discussing this morning. As Lorraine did, she was talking about, forgive me, what was it, Andrew?
Enduring powers of attorney.
Enduring powers of attorney. So Andrew is happy to answer all of those questions. All right. We're coming to that. So, Andrew, you pointed to a question.
Oh, yeah. I was going to discuss about financial agreements. So since we're talking about blended families, we've talked a lot about wills and estates and what happens if someone dies, but also what happens if the relationship ends.
Yes.
So overseas, for many years on TV, you hear about a prenup. That does exist in Australia to a certain extent. We call it a binding financial agreement. And the binding financial agreement lets you quarantine your assets. So this is something to consider if you're in a de facto relationship or go about to get married, and you have a blended family. You may want to, from day one, make sure that you understand the control and what happens with those assets.
All right, we might come back to that information. Andrew, we've got we've got a caller, and we'd also love to hear from you. 0755 208888 is the number if you'd like to pose a question to Andrew this morning. John, answer your question or ask your question of Andrew.
John, the only way around everything is to cash it in before you have your last breath. How long have you got before your last breath to actually make sure everything's in line?
That's very philosophical, but as long as you have capacity, you can enter into any of these arrangements any time up until your death. You don't need to cash things in. You don't need to sell things just to make sure that people are protected. A lot of these arrangements that I've talked about today, whether they be your death nominations, your life insurance, setting up testamentary trusts, etc., can all be done without selling assets.
Well, it's just capital gains tax and stuff like that.
There is capital gains tax, but you may actually, I can't give you financial advice, but you may be better off not selling things before you die. Assets like your family home have a 2-year period where there's preferential treatment for capital gains for the people who are going to receive your property, and otherwise you would be liable for it if you sold it before you died.
Yeah, and commercial property?
Okay, we would have to go into specifics there around commercial property and how you're owning various devices. And as I said, some of this would need financial advice. But on the whole, the advice is not normally to sell assets before you die, but to make sure there's protective structures in place that are most tax advantageous to you.
Anyhow, that's great. All right, thanks very much.
Good on you, John. Thank you very much for your question. All right, we've got a few minutes left in the program. We'd love to hear from you. And the number is 0755 208888. Do not leave it too much longer. We might not be able to take your call. All right, Andrew, we're in our final 3 minutes of the program. Did you want to move into a summary, or did you want to...
Sure. I'd love to go through some of the things that I was hoping you'd take away if we didn't get calls.
Yes.
So, again, if you've got a blended family, some of the things that you could take away to protect your family is, one, a will with a testamentary trust. So it's really the only way to provide tax-effective income to a spouse while legally locking in the capital. Alternative, you can do the mutual wills that we discussed briefly previously, where both sides commit that they're going to distribute the assets the same way, but that does provide risks to the surviving parties. The second thing would be that make sure you have that binding death benefit nomination. Try and make it non-lapsing if possible. Decide who is going to inherit and how that fits in the grand scheme of your will. Third thing that we didn't really touch on, but Lorraine brought it up, enduring powers of attorney. Make sure you have one of those in place so arrangements can be made for your estate if you do lose capacity. Number 4, a big one of the biggest ones I see for the blended families is the property title review. Who actually owns what property and what capacity? Make sure that you can pass on what you think you can pass on. Make sure it's structured in a way that reflects what you want to happen with your property after you die. And that may mean a trip to the lawyer to change how you actually own that property. And the final major tip was the binding financial agreements. If you're in a pre-relationship or you're worried about how things go, make sure that you can document and have a mutual agreement about how assets are going to be dealt with before you're in conflict rather than afterwards. And a final takeaway would be you should be having these conversations regularly with your partners and your children so there's no surprises. But pick the time that you do it. I hear a lot of family fights happen when people decide that this would be a great thing to discuss over the Christmas table or when people are camping for Easter.
Yes. And they can go one way or the other, can't they?
They can. It's, planning for the future is important for everyone, but often if it's not raised the right way, can feel like an attack. But everyone needs to be protected. So it's about raising it the right way and making sure you have these conversations regularly.
Look, it's always good to have a plan. It's always good to have prepared yourself for any type of situation. No matter how old we are, we all think that we're bulletproof. And at the end of the day, the older you get, something can turn up very, very quickly and take the wind out of your sails. And it means if you've got a plan, family know about it and understand what your wishes are, then there's no surprises, no arguments, and everybody's on board. Great show, Andrew. Absolutely fantastic information. We did have a number of other questions and queries which I thought were valuable that we didn't get to, but we might tackle those in a coming show depending upon the topics we've got coming up.
Sounds great. And if people want to ring in their suggestions or questions in advance, then we're happy to consider those as part of a future topic for the show.
Don't forget you can pose your questions via email, mail@4crb.com. You can also text the questions in if you'd like to. And just remember that legal answers can be a little more complex than just a quick answer. 0451 220 is the number to text in your questions, and they'll be answered in the next show. Otherwise, we look forward to your company next Tuesday at 9 o'clock.
Thank you, Colin. Can't wait.
Legal issues don't need to feel overwhelming. Call our trusted sponsors, Bell and Senior Lawyers. They explain everything in plain English and guide you through every step of the way. For caring, experienced advice, phone 07 5532 3133 or head to bellsenior.com.au today. Bell and Senior Lawyers, making legal matters simple. You've been listening to Legal Matters, proudly brought to you by our trusted sponsor, Bell and Senior Lawyers. Call them today for all your legal needs on 07 5532 8777. A copy of this and past programs and all relevant resources will be available for you to replay or download on bellsenior.com.au and 4crb.com.